Mr. Scholl.
Chief Justice Marshall, and may it please the Court, my name is Robert Shaw, and I'm privileged this morning to appear on behalf of Stephen Kenney. Child pornography, the documented sexual abuse of children, is repugnant to the morals of a decent society. It is abhorrent to the vast majority of citizens, and it is appropriately illegal. This appeal is not about the prohibition of properly designated child pornography. It is rather first about Chapter 272, Section 29C, and whether that statute sweeps too broadly, and second, about what constitutional threshold will be required before police can invade one's home because they harbor the belief that they will find contraband on a computer.
Well, on the first point, I take it that we can construe the statute to be constitutional and limit its reach.
I want to acknowledge at the outset that the Court has the power and the prerogative to do so. And with that in mind, it is my intention this morning to convey that even if the Court looks at language permitting a depiction by computer and a simulation to pass constitutional muster by virtue of a limiting construction, the statute still remains unconstitutional. And the statute remains unconstitutional because it identifies as child pornography a vast array of imagery, imagery that is in scope far beyond anything that any other statute in the country prohibits. It would, for example, prohibit an image of a 16 or 17-year-old who is involved in acting out a simulated scene that is not really occurring, where there is no nudity. It need only present the subject as an object of lewd touching or lewd caressing without any consideration of context, such as whether it is meant to appeal to prurient interests, whether it was created with lascivious intent. And in addition to that, the statute involves no exemptions for the arts, for science, for medicine, and it does not provide for an honest mistake defense, something that is largely precluded by the scienter requirement, something that I'll address separately in a moment.
The other statutes in the other states provide those kinds of things?
They do. They do. Massachusetts, as indicated by the amicus, is one of the broadest statutes in the country. And while there are some other statutes that do not involve exemptions that I've just mentioned, for example, typically that can only be judged with reference to how narrowly drawn the statute is. And the problem with the Massachusetts statute is that it is extremely broad. And when you combine its broad terms along with no reference to prurient interests or lascivious intent, and then you add on that there are no exemptions, you really do run into an irreparable problem. Now, the United States Supreme Court in Ashcroft versus Free Speech Coalition made very clear that child pornography is designated as such by its means of production, not the way speech is presented, not the content of the picture necessarily. It is the means of production. The picture must be intrinsically related to the sexual abuse of children. And so I think that the proper question for the court to ask is, when looking at these terms, does this statute prohibit only images or close to it, images that are intrinsically related to sexual abuse? And I think that it's clear.
No, there's a pretty big exemption for organizations who and people who work for them to do this or look at this for purposes of furthering legitimate goals of the enterprise.
Certainly, and I think that's directed.
So that covers your artists.
Oh, I don't think so, Your Honor. I don't think so. I think that addresses ISPs, Internet Service Providers, who are trying to be sure that people are not posting pictures of child pornography. And certainly there's no issue with respect to child pornography that is really toward the inner core. I mean, certainly nobody's going to argue when they see a very young child in a sexual context.
Can you point me to a state that's got a better exemption?
And
if so, what the language is?
Well, I certainly, I can't off the top of my head right now, but I can assure Your Honor that they do exist, and I believe that they are listed in the amicus, and I will, if the court will allow me to
Well, if it's
present
in the
them
amicus, that's all right. We'll find them.
to the court.
Essentially, as I understood the amicus brief, is that if you looked at the Massachusetts statute, that really is that, at least as the amicus argue, and the Commonwealth can rebut that, every other state has some piece that limits it. They don't all have the same piece that limit it, but they all have some piece that limit it. Am I correct?
Certainly, they do. Again, it is looking at a statute and looking at all the elements. Here we have the problem that not only is it extraordinarily broad language, but there are no exemptions. For example, there are statutes that exempt artistic endeavors, education, cultural purposes. There are statutes that provide an honest mistake defense. Here, again, that is not provided for. And so,
but isn't the honest mistake taken care of by the fact that the statute says that he should reasonably know the age from the photo?
I don't believe so, Your Honor, because, in fact, when one looks at that scienter requirement, that requirement permits conviction and imprisonment if a jury concludes that a defendant did not know.
But the Commonwealth has to prove beyond a reasonable doubt that the defendant reasonably should know.
Exactly. But
okay, so if he reasonably should know.
Right, but then again, there are going to be a range of cases where there is ambiguity, and a jury can certainly say, well, we think he reasonably should have known. But in fact, the jury could still determine that the defendant did not know. Now, the problem is that there's a range of cases where there's going to be ambiguity. Ambiguity can exist because there's a misassessment as to age. Ambiguity can exist because there's a compilation and a defendant is unaware of the offending material which is part of that compilation. And there can be ambiguity because a defendant comes into contact with a picture such as surfing on the Internet, and there are real questions about whether it was volitionally possessed, such as when a picture comes into the computer system's memory, its cache. Okay? All of those situations involve ambiguity. And all of those...
Mr. Shaw, this case does not involve ambiguity, correct? I mean, this is a 5- or 6-year-old child, correct?
Well, Your Honor, there were multiple pictures that the Commonwealth presented. They brought one indictment. It's not possible to know what image the jury relied upon.
Did it include pictures of a 5- or 6-year-old child?
Your Honor, I would say, as indicated in the brief, that there was some of the imagery which met the core definition of child pornography. That's correct in this particular case.
So we're clear that the statute, that child pornography has to involve real children. Right? Commonwealth has a burden to prove that the person in the picture is a child.
Certainly, sure. And a child could be real or virtual.
Well, why virtual? I thought Ashcroft was pretty clear that you can't bar virtual depictions. In other words,
certainly.
Computer animations or things that aren't real pictures.
The court must, in other words, the court must construe the statute so that it is a real child, correct. Whether that's what the legislature intended, whether the scope of the language would cover something else, that's a question for the court.
What doesn't seem to be covered by Ashcroft is this question of simulations, which frankly I'm not quite sure I understand. I understand the Dakota Fanning simulation, which is a child, someone who was under the age of 18, in a movie simulating, I assume, sexual intercourse.
Right. Well, Your Honor, I would suggest that Ashcroft does cover that, because what Ashcroft says is that the imagery must be intrinsically related to the abuse of children. If there is no
child abuse no actual child abuse in the imagery, then that's a failure of proof.
That's correct.
Couldn't be covered by the statute.
Well, I mean, this statute would certainly cover it.
Well, we could interpret simulation to refer to the act and not the image. And then would that solve the problem?
Well, there are two problems, and to be sure they don't get confounded. One is that if there's a computer simulation of something with unreal people that isn't actually occurring.
Take that off the table.
Okay. The second situation is where there is a simulation where that's correct. There are they're engaging in activity which is not really occurring. They're feigning it. It's not really occurring. It's just meant to look like that. Now, Ashcroft says that child pornography must be related, intrinsically related, to the sexual abuse of children. Again, going back to that principle, that it is not the content of the image, it is the means of production that makes it child pornography. Now, the problem with this statute is that it most certainly covers activity, simulated activity, because all it would cover is lewd touching or lewd caressing, whatever that may be. And again, there is no reference to context.
But we can narrow the construction.
Well, you can narrow the construction, certainly. The problem is that when one is just looking at an image, it is very difficult to get into discussion or determinations about whether it is lewd touching or lewd caressing.
But
And
Mr. Shaw, that's never been a problem with the statute. This happens to be a computer case, but I mean, any such image, it seems to me, is a factual determination. In other words, I'm not quite sure what your problem with the statute is, that you can have, that you can't tell if a child is a child, or that you can't tell whether the act that is depicted is lewd.
Both, Your Honor, certainly, because there's going to be a range of imagery. For example, older teens, 16 to 18, where there can be mistakes as to judgment as to age, number one.
Well, as to that, as you know, the Commonwealth informed us that they would rely on the recent case, which was the Supreme Court of Minnesota, which I take it your problem there is that you reasonably should know. Obviously, if the defendant knows that this is a child, we don't have a problem. Here, it's whether you reasonably should know. And what is your problem with Minnesota's interpretation, saying that that's perfectly constitutional?
If that was something that was submitted by the Commonwealth, I haven't seen it prior to the oral argument, but in any event, I can still answer the question. The problem with should have known, is that what Your Honor is asking?
Yes, because it seems to me if you know that it's a child, I raise two things. Does the defendant know that it's a child, and is it lewd? If the defendant knows that it's a child, we're over that part. It's the statute provides for reasonably should know.
Right. The problem with reasonably should have known is a term which will permit a jury to convict, even if they determine that the defendant did not know. That is the problem with it. Now, if you look to
What's wrong with that?
Well, there's a lot wrong with that, because a defendant may be convicted without a culpable state of mind. And again,
But he has a culpable state of mind. He reasonably should have known.
Well, should have known, that's really a negligence standard. And for example, if it's a situation involving a compilation, the fact is that he literally may not know at all. It may just have been a total lack of awareness because he wasn't aware of the offending material. Now, it is true that in some situations, for example, statutory rape, there is a situation where the law imposes a burden on the citizen and says you are acting, this is conduct, it's going to affect a child, and therefore you have a burden to bring about certainty in an uncertain situation, get verification, ensure yourself that you are not dealing with a child in that situation. That can occur because there are surrounding circumstances, there is face-to-face meeting. The law says proceed at your own risk. Okay? This is not a situation where that can be done, because we are dealing here with pure speech, not conduct. And the law cannot put that kind of burden on pure speech. If the court looks at Smith versus California, the United States Supreme Court, that is essentially what that court says.
But it's not pure speech. Isn't it speech that's enticing a child under the age of 18 to engage in sexual intercourse?
No, the statutory rape is conduct. That kind of offense is conduct. possession of child pornography is pure speech. It is not even a speech-conduct combination. Like, for example, if somebody was posing a child in the nude to take a picture, one might say that that is both speech and conduct. Here we are talking about, with the possession of child pornography, it is just an image and it is just possession. And so when we are dealing with pure speech, that kind of burden cannot be placed upon speech. Not only that, but it is impossible when dealing with just an image to get the kind of verification to bring about certainty, because all you're dealing with is an image.
Thank you, Mr. Shaw. Your time is
thank you.
up. Thank you. Ms. King?
May it please the Court, Michelle King, Assistant District Attorney for the Commonwealth. It's undisputed that child pornography is not covered under the First Amendment. The United States Supreme Court said in New York v. Ferber that the evil to be restricted is so overwhelmingly outweighs the expressive interest, if any, that states are entitled to very broad leeway in regulation of child pornography. I would suggest to you that that's exactly what the Massachusetts legislature has done here. Now, a number of the issues that the defendant has raised, because we're dealing with only an analysis of the federal Constitution here, a number of the issues that the defendant has raised are in fact covered under the United States Supreme Court ruling in Ferber. I would suggest to you that first...
Ms. King,
Yes.
I take it that the issue is, in one sense, is the statute sufficiently narrow that a defendant knows that it is pornography?
Yes, that would be the void for vagueness argument that the defendant makes, Your Honor.
Right. Could I just ask you about the Minnesota case? The Minnesota case, as you know, cut back the language, had reason to know, and substituted, they interpreted reason to know as that the defendant has to be in some manner aware. Could you explain to me as best you can, because you told me that you were going to rely on it, what the difference is between has reason to know and in some manner is aware that the performer is a child?
Well, I would suggest to you, Your Honor, that the Minnesota statute says has reason to know, whereas ours says reasonably should know, and I would suggest to you that the language used in some manner aware actually tracks better our language, reasonably should have known. So that when you're talking about actual knowledge of an age of a child, that would be if a defendant possesses an image of, say, his neighbor, and he knows that the neighbor is 6 years old. Whereas in some manner aware or reasonably should know would be in cases such as here, where the defendant had a file name labeled "cum-covered baby," and in fact had multiple images of infants and children on his hard drive and on computer disks. So I would say that that is the specific difference between knows and reasonably should know, and that our statute should have some reason to know or reasonably should have known.
But what it seems to me that you've just given me is in some manner aware, namely he's labeled it. I mean, so that it's not a completely objective test, it's a subjective test. He is in some way, in some manner aware of it. It seemed to me that Minnesota was really not doing a reasonably should know.
Well, first off, I would just say that the possession aspect of itself is a knowing possession. Okay, so you have to know that you have an image to begin with, and the Commonwealth doesn't dispute that. But the in some manner aware with regard to the reasonably should have known, again, I would suggest to you that the Commonwealth of Massachusetts decided to phrase its language in reasonably should have known does not need a narrowing in construction, because in fact that is essentially what the language in some manner aware means, is that he reasonably should know what the image actually is. And again, that is the Commonwealth's burden to prove.
Can I go back to the beginning? You said clearly child pornography is not protected by the First Amendment, but it seems to me the statute requires that we decide what child pornography is. And if you look at Ferber, it says where speech is neither obscene nor the product of sexual abuse, it is protected by the First Amendment, right? So we've got what's depicted, and we know from Ashcroft that what's depicted has to be an actual child
Absolutely.
engaged in actual acts, right?
No, it doesn't have to be, can be an actual or simulated act.
Where do you get
of
that?
an-
Where do you get that in Ashcroft?
In Ashcroft, it talks about the ruling in Ferber, where it says that Ferber talked about simulation which would be outside of the statute. And it talked specifically that the language in Ferber said simulation outside of the prohibition of the statute could provide another alternative. And the court said then Ferber not only referred the distinction between actual and virtual child pornography, it relied on its reasoning to support its holding. So the holding in Ashcroft talked about the difference between a simulated act as well as a simulated child.
But the fundamental holding is, I thought in Ferber, is that it has to be this photo, this image, has to be the product of sexual abuse. And if it is a simulation, which does not constitute sexual abuse, then how can it be a product of sexual abuse?
I'm not sure that we're talking about the same term. If you look in the Massachusetts statute that it says actually or by simulation engaged in an act. So you're talking, in that regard, if you want to use hypothetical.
Let's use the Dakota Fanning case, for example.
Okay.
A child in a bodysuit in a film depicting a rape of a child.
I would say that under the Massachusetts statute, which provides no exemption for artistic value, that could be considered child pornography.
So this is a problem, wouldn't you say?
I would not. I would say that the United States Supreme Court said in Ferber that when you're involving child pornography, that there does not have to be an exception for artistic value. Specifically,
so in other words, we know that, and you know, that sexual abuse is a huge problem in this Commonwealth.
absolutely.
So to make a film about it involving simulation, so no actual sexual child abuse has taken place, would be illegal.
It would. And in Ferber, the United States Supreme Court said if that type of a simulation was necessary for an artistic value, you could use a child who was over the age of 18 to portray a younger child so that it would not offend the statute in question.
Given the problem of child sexual abuse here, why is there anything wrong with saying that simulation would be illegal? Since the United States Supreme Court has said that child pornography lacks any redeeming social value, and it's all right if there's no exception for that. A simulation simply encourages the actual act. So why isn't a simulation just as much of a problem, almost as much of a problem as the actual image?
Are we talking about a simulated image or a simulated act, Your Honor?
Simulated act.
A simulated act is a problem under the statute.
That's what I'm saying. Why shouldn't it be? I'm saying there's no problem.
I agree with,
I can see.
I wholeheartedly agree with you, Your Honor. There's no problem with a simulated act because if you have a child, a live child, an actual child who is...
But I'm saying also that would apply to a simulated image because what value is there in a simulated image?
Well, the United States Supreme Court in Ashcroft said, Your Honor, that the problem with a simulated or virtual image is that it does not require the participation of an actual child.
Neither does a simulated image. In other words, you can take a child who is clearly a child and with contemporary mechanisms of how you use computers, believe me, you don't have to put a bodysuit on. You can have the computer do the simulation. So I think that was the gist of Justice Cordy's question.
That's a different question, Your Honor. That's the question of morphing. So if you have, and the United States Supreme Court in Ashcroft said that that was an open issue. So
I understand. So I'm just trying to find out where you are on that issue. You're clearly saying that in the hypothetical Justice Cordy gave you, where you have a child,
an actual child
who is actually acting but simulating, let's say, a rape.
Or lewd touching.
Or lewd touching. You say no problem.
I say that's no problem. I say that the
statute
statute is constitutional in that regard.
And that's a prosecutable crime, no matter why it's being made. Social awareness, artistic, scientific documentation, no matter.
In the case of overbroad application of a statute, the courts are allowed to look at each individual case on a case-by-case basis. That's been affirmed by this court in Commonwealth v. Provost.
But if we know that it will encompass a whole variety of communications that will be chilled by the fact that the statute appears to cover it, don't we have an obligation at the get-go?
Well,
to do
first,
something about that?
there's been no evidence provided that this presents a very large or vast problem, Your Honor. In fact, the United States Supreme Court in Ferber said that images of the nature that would be covered outside of the statute for artistic purposes result in only a tiny fraction of the materials that they're seeking to prohibit under the statute. So again, if you look at a close reading of the Ferber case, which analyzed a New York statute that was significantly similar to the Massachusetts statute, they said, first off, that the lewd exhibition of genitals was constitutionally fine. They also said that actual or simulated sexual conduct is constitutional. And so I think you're bound by that holding here.
Constitutional? I'm sorry, actual or simulated sexual conduct
Is
constitutionally
not overbroad.
We're dealing here with an as-applied challenge, aren't we?
We are not, Your Honor. It's a factual challenge. The defendant here has admitted that what he possessed was child pornography.
Ms. King, you're being extremely helpful, if that's any help to you. The Ferber case is 1982.
Yes.
I think we can practically stipulate that what you have referred to as morphing was not as sophisticated in 1982. So
Absolutely.
the way I at least read Ferber was that the simulation is the child, him or herself, simulating. In other words, they are not being abused, but they are simulating being abused. I mean, there are cases where the children are actually being abused, but for some reason you get a simulation.
Simulation would be in that regard if the child were lying there and it wasn't actually sexual intercourse, but they were lying there simulating sexual
Correct.
intercourse.
Well, the very fact of simulation might be abuse. I mean, if it's a
Absolutely.
naked child being filmed in certain circumstances, that might be abuse. In
Absolutely.
itself, but it may not be either.
It may not be, but the court in Ferber said that that's a tiny fraction. The may not be is a tiny fraction of the content that we're talking about here.
Go ahead, I'm sorry, Chief.
Can we just get to the morphing question? One way to read the Massachusetts statute, which I think is a fair way to read this statute, is that when you get to subparts 1, 2, and 3, and you get to the actually or by simulation engaged in any act, we could read that statute to say it doesn't deal with morphing. Whatever else it deals with, what it's dealing with here is actual children actually engaged in acts, not with morphing, correct?
Absolutely, and I think the enabling statute helps you in that regard, but it
That'd be a
speaks.
fair reading of that, so we don't have
It would
to
be.
think about what happens when you take a picture of a child and you then superimpose pictures of genitals or whatever it is.
Our statute has nothing to do with morphing, Your Honor, and it's clear from the enabling statute that speaks about it talks about children, and a child is an actual child, not a virtual child. The language in the Ashcroft case that the United States Supreme Court found offensive was the appears to be or gives the impression that it's a child. We have none of that in this statute.
Okay. Thank you.
With regard to the defendant's argument of depiction by computer, the Massachusetts statute was enacted in 1997, of course. Ferber came after that. But the definitions...
Before.
I'm sorry, Ashcroft came after that. The statute for definitions under 272, Section 71, was amended after Ferber in July of after Ashcroft in July of 2002 to contain the phrase depiction by computer. And certainly the Massachusetts legislature could be aware of the court's holding in Ashcroft so that depiction by computer could not be read to be virtual child pornography, as the defendant claims here. In addition, this court said in Hines that the phrase depiction by computer has to do with the form on the computer itself, the actual, the fact that it's an intangible and can then subsequently be produced to be a photograph or a picture of paper. So in that regard, depiction by computer, refers to the method by which the image is displayed and not its content. In conclusion, I'd just like to say that child pornography is simply on a different level than any other type material that has been found unconstitutional or analyzed under the obscenities statutes. This type of material, child pornography, every court to address this issue has said that states are allowed to broadly define child pornography, and I would suggest to you that the Massachusetts legislature did that purposefully.
May I go back just to one?
Absolutely.
Which is the scienter question. Other than the Minnesota case, are there any other, I mean, I know this is a broad question, but are there any other states which should have known language and have held them to be constitutional?
Your Honor, there's only, I believe, 2 other states that have the should have known language. Illinois, which does have an affirmative defense, but also Michigan. And as far as I know, there's not been a constitutional challenge to that. The standard or the language from Michigan is knows, has reason to know, or reasonably should know, which is, of course, the same language that we have. As far as I know, that's not been held unconstitutional. There was one case, the Girard case, which said on a sufficiency that the Commonwealth met its burden of reasonably should know, but there was no constitutional challenge in that case.
Thank you, Ms. Kenney.
Thank you.